Can you please introduce yourself, Hunney Mittal?
Sir, I come from Gannor, which is in district Sonipat of Haryana. I completed my law from Guru Gobind Singh Indraprasth University in the year 2020. Thereafter, I started my preparation for the Judicial Services examinations, and this is my second interview of Haryana Judicial Services.
So last time, in which year did you give your interview? Last year?
Yes, sir, in 2022.
Why do you think you couldn't crack it up at that point of time?
Sir, I was not able to perform well in my mains examinations.
Interview was good.
Yes, sir, I had got reasonable marks in my interviews last time.
What was the reasonable marks according to you?
Sir, I got 85 marks out of 200.
So
Good.
that would be only 42.5%.
Yes, sir, but considering the average marks that were awarded last time, I would say that my marks were reasonable.
So the panel was strict that point of time.
Sir, I don't think I'm competent enough to comment upon it.
So tell us about your family background.
So my father works as a commission agent in the grain markets, and my mother is a homemaker.
No sibling.
My younger brother, he is currently working with a startup.
So don't you consider him to be your family?
Sir, I apologize, I forgot to mention about it.
So why do you want to become a judge?
So judiciary, as we know, is one of the most respected organs of the country, in which common man has a lot of faith in. At the same time, it promises a career which is exciting and a great learning experience. Further,
So
I
life
will
is,
be further I will be under the able guidance of judges from the state of Uttar Punjab and Haryana. So this is one of the reasons why I want to be a judicial officer.
guidance is always there from in any field by
Yes,
very good mentors.
yes.
So do you think you have the panache for becoming a judge?
Sir, to my limited knowledge, I do feel that I have the skills that it takes to be a judicial officer.
What are those skills?
So, firstly, a judicial officer, to my limited knowledge, must have some basic knowledge of the laws, and he must have an analytical mindset. At the same time, he must be patient, and he must be hardworking.
When was the last time you have utilized your analytical mindset?
Sir, just can I take a few seconds to recall?
Oh yes, please.
Sir, just now I analyzed the facts and uh, came up with an answer. So I feel that this is the last time I applied my analytical mindset.
But when I ask you question, you have and about the last time should have been something which is past than the time when I had asked the question.
Uh, right, sir. I apologize.
So that would not be analytical, no? But
Right,
you
sir.
had answered. There might be. Have you ever analyzed a judgment?
Yes, sir.
Which judgment?
Sir, the last judgment that I recall was Sukhpal Singh Khera versus State of Punjab.
So 319.
Yes, sir.
What was the decisive factor and what was held in that judgment?
So the judgment basically it laid down the rule as to when additional prosecution can be allowed. So it had made a distinction between acquittal and conviction. So when we talk about acquittal, when additional prosecution has to be made, then the same has to be done prior to the acquittal. But in cases of conviction, an additional prosecution can be made after the previous accused is convicted, but before the sentence is passed.
So before quantum,
Yes, sir.
it has to be done.
Yes, sir.
Did Hardeep's judgment on 319, which was a landmark judgment, talks about this aspect?
Sir, I did not come across this aspect in Hardeep Singh.
So it does not basically.
Yes,
Basically
sir.
does not.
Yes, sir.
All right.
Okay, Honey, tell me one thing. How would you handle a case where the evidence is entirely circumstantial?
So when we talk about circumstantial evidence, I will consider whether a chain is complete so as to rule out any reasonable.
How you are going to handle the case? If the case is entirely based on the evidences that are circumstantial in its nature, as a judge, how would you handle?
Sir, I will consider the evidences that are on the record, and I will see if a chain is formed so as to rule out the innocence or the non-guilt of the accused.
Is anywhere the circumstantial evidence is defined under the Indian Evidence Act?
No, sir, it is not defined, but the same is relevant under Section 8 of the Indian Evidence Act.
Okay, how can we define circumstantial evidence?
So circumstantial evidence, as is evident from the name, it refers to it refers to the facts that arises from the circumstances, and it is applied in the case where
What
direct
is the
evidence.
evidentiary value of circumstantial evidences?
So the same has to be considered if the chain is complete. In case the chain is
Can the
complete,
person be convicted solely on the basis of circumstantial evidences?
yes, sir.
Is there any leading judgment you want to cite?
Sir, there is a case, Sharad Birdi Chand Sharda versus State of Maharashtra, which talks about the same.
Okay, what are the 5 golden principles laid down in this judgment?
So firstly, the facts must be proved and not may be proved. Secondly, the facts must be consistent with the guilt of the accused. Thirdly, the facts must form a chain so complete that it rules out any factor which is in compliance with the innocence of the accused. Fourthly, the chain must rule out the chain must only result into the conclusion of the guilt of the accused.
And fifth one?
Sir, I apologize, I cannot recall the fifth point at this time.
Okay, which subject do you like the most, Honey?
Sir, evidence law.
Evidence Act. Okay, how many sections are there in Indian Evidence Act?
Sir, 167 sections.
Okay, what are the major changes brought in your newly enacted Bharatiya Sakshi Adhiniyam?
So firstly, considering the changing times, the technology element has been introduced. Now, as far as electronic evidence is concerned, it has been made more comprehensive. And for example, when we talk about primary evidences, when something has been recorded in an electronic device or a digital device, when the same device is produced, it is a primary evidence.
Okay, which sections of the Indian Evidence Act talks about the relevancy of a fact?
So Section 5 to Section 55 talks about relevancy of facts.
So Section 5 provides for the relevancy of what kind of facts?
Sir, it provides for facts which are relevant to the case.
Relevant to the case. So Section
Yes.
5 generally creating any kind of relevancy, or it's only provides a right to produce the evidences before the court?
So Section 5 makes such facts relevant.
Are you sure?
Yes, sir.
Can you recite the Section 5?
Sir, I apologize, I cannot recall the
Okay.
term.
What is this closely connected facts? Is there any difference between relevant fact or closely connected facts?
So when we talk about closely connected facts, it refers to facts which are closely connected to the relevant facts or fact in issue. So
For
in that,
example,
sir, for example, when we talk about res geste, so generally facts are not considered in isolation. They have to be considered along with the surrounding circumstances. So this refers to the connected facts, and the same shall be relevant under Section 6 as part of res geste.
okay, what is your understanding of the concept of procedural fairness?
Sir, as far as procedural fairness is concerned, I believe that there may be some inconsistencies or some irregularities. So we cannot decide. So can I take a few seconds to think about it?
Yes, yes, please.
So when we talk about procedural fairness, we generally consider two things. Firstly, whether there is any material irregularity or whether there is any illegality. When we talk about irregularities, it refers to certain procedural lapses which do not affect the trial or which do not
Is there
affect
any
the.
provision under the Code of Criminal Procedure which talks about irregularities which affects the trial or which does not affect the trial?
Yes, sir. So Section 460 and 461 talk about irregularities and illegalities which may or may not affect the trial.
How many irregularities are provided in this section?
Sir, I apologize. I cannot recall the exact number.
Okay. What is this suits of civil nature? How can we find out that this particular suit is a suit of a civil nature? Is there any clear-cut bifurcation or is there any straitjacket formula which can apply to find out that this particular suit is a suit of civil nature?
So when we talk about suit of civil nature, firstly, there is no straitjacket formula. The court has to consider on the facts of each case whether the same is a suit of civil nature or not. And when we talk about suit of civil nature, the basic test that the court has to see is whether the predominant nature of the suit, whether it pertains to any civil rights or not. If the same is purely based out of religious rights or any other political rights, then the same shall not be considered as a suit of civil nature. The scope of suit of civil nature is wider
Can you
than.
give us the examples of suits of civil nature and which do not fall under the category of suits of civil nature? Two examples of both.
Sir, when we talk about suit of civil nature, uh, for example, the right to take out religious procession, it pertains to my fundamental rights and it will be a suit of civil nature. Second, a suit of declaration, that will also be a suit of civil nature. And when we talk about suits that are not of civil nature, it is where a case when a person has been excommunicated from his caste and he has filed a suit on merely on such excommunication, on from which he does not derive any such rights. So that is not a suit of civil nature. Thirdly, the when we talk about uh, so can I take a few seconds to
Yes, yes,
think?
please.
Thank you, sir. Sir, the suits which are out of purely religious rights, they are also not of suit of civil nature.
Can a magistrate is empowered to inquire at the stage of taking cognizance?
Sir, could you please repeat your voice?
Can a magistrate is empowered to inquire at the stage of taking cognizance?
Sir, I apologize. I did not understand properly about what inquiry he has to make.
Whether he can make one or he cannot make one. Suppose police file challan against 5 persons. Can he inquire and a certain unknown person? Can the magistrate inquire about the facts for finding the identity of another persons who are being deemed as unknown?
No, sir.
So basically now the statement is that magistrate at the time of taking of cognizance cannot inquire, cannot entertain an inquiry.
No, sir.
Can a police magistrate ask police to reinvestigate the matter?
No, sir. Reinvestigation is not
Further
with.
investigation.
Yes, sir. Further investigation may be done.
So the hands of the magistrate are tied and he is dependent upon the investigating agency.
Sir, as far as investigation is concerned, it is purely the prerogative of the investigating agency. However, in cases the magistrate may oversee, and in case where he feels that something needs to be done, he may direct the same, but he cannot control the day-to-day investigation process.
Can he choose not to take cognizance of a report filed by the police?
Yes, sir, he may choose to not take cognizance upon the same.
Can you give me an example?
So, for example, where the police has filed a charge sheet where they have where they have where they recommend that charges may be framed against the accused person, let's say under section 323 of the IPC. Now, in such a case, the magistrate is free if he sees on his own that the no case is made out or no offense is made out, then the magistrate may choose to not take cognizance against the accused person.
Are you sure about it?
Yes, sir.
Whether the magistrate can say that can the magistrate discharge at the stage of taking cognizance?
No, sir. The stage of discharge comes at the time when charges are to be framed.
How will a magistrate let free of the accused at the stage of taking cognizance?
Sir, the magistrate can see whether whether the facts, if considered correct, which are to be brought, which have been brought on the police report, whether they reveal that any offense has been committed, or whether they at all reveal that the accused was there at the time when the offense was committed.
So he is to see the records, sift through it, and make a prima facie opinion.
Sir, no, sir, he does not have to make a prima facie opinion. He just have to see whether the facts, which, if correct, even if they are considered correct, whether they reveal any offense has been committed or not.
So what sort of application of mind has to be done at this stage?
Sir, detailed examination is not to be done as evidences are not yet brought on the record, but he may just have to see whether cognizance as whether some facts are there against the accused or not.
So the cognizance of the offender or the offense is to be taken.
So cognizance of an offense is taken.
All right.
Honey, what are your hobbies?
Sir, I like to play chess and Casio.
So you are a sort of musician also.
Sorry, sir.
So you are sort of a musician also. Casio you play.
Sir, it is purely for entertainment purposes. I do not perform it really well.
So you can play good songs, I suppose.
Yes, sir.
So tell us your strengths and weaknesses. 5 strengths and 5 weaknesses.
Sir, as far as my strengths are concerned, I am a determined person, determined and hardworking. I have patience and perseverance, and at the same time, I believe in. Uh, I'm open to constructive criticism. And as far as my weaknesses are concerned, I have stage fright. I fear public speaking a little, and I am a little miser. At the same time, I am not very fluent with my English.
That
So
is not
these are,
a that is not a weakness. It is a second language. We are learning it.
so certainly it is a second language, but it helps you progress in the society.
So you are a miser or you are a frugal person.
Sir, I'm a miser because I fail to understand as to how I should spend my money or not.
Again, so you have converted your weakness into strength. So you are a
Sir,
smart person who has yet failed to understand how the money is to be spent, so you don't spend it. Because the moment you will spend it, you will only spend it by like a person who understands the value of the money.
sir, I really hope to do the same.
That would be your what? That is not a weakness under any circumstance.
Sir, at times it may prove to be against me. For example, where I should have spent money and I have not done the same, I may have to face consequences.
All right. See, only so now that the interview part is over, let me give you a small advice which was given to me on this miser part. The principal of my school once told me that Vivek, if the amount of money is to be spent huge and that can save your time, and at that particular point your time is valuable, then you should not be hesitant in spending them.
Yes.
So basically, if your time is valuable and you have important tasks to complete at that day, in that case, see, you have to prioritize.
नहीं नहीं
Value
सर,
your time above money.
ये तो बस मैंने इंटरव्यू के लिए किया है. so that it does not affect interview.
हनी यू आर गुड टू गो यार, मतलब जो मैंने एनालाइज
तो
किया और ऑब्जर्व किया, लो आपका बहुत अच्छा है, ठीक है। कॉन्फिडेंस थ्रू आउट द इंटरव्यू बड़ा बैलेंस था, एनर्जी है, टोन आपकी बड़ी बैलेंस थी, आई कांटेक्ट आप प्रॉपर कर रहे हो, सो यू आर
Thank
गुड
you,
टू गो फ्रॉम माय साइड। 100% आपका सिलेक्शन होना चाहिए दिस टाइम।
thank you, sir. Thank you, sir.
हाँ,
यार
मेरी
बस
तरफ से
मेरे
ऐसा कोई मेजर इंप्रूवमेंट्स की रिक्वायरमेंट नहीं है ना, सारी चीज बहुत अच्छी है, परफेक्ट है आपकी। मतलब वो जो एक पर्सनैलिटी होती है वो भी है, ज्यादा नहीं बोलना, लिमिटेड बोलना, टू द पॉइंट आंसर करना, एवरीथिंग गुड, गुड टू गो।
Thank you,
यार
sir. Thank you.
मेरी तरफ से बस एक ही सजेशन है, अपन ना ऐसे जैसे दो शब्द आपने बोले जिसमें थोड़ा सा प्रॉब्लम हो जाता है एक्चुअली में प्रैक्टिकल पार्लेंस में। पहला तो है कि ये आपने बोला था कि क्रिटिकल एनालिटिकल आपके अंदर टैलेंट है,
हाँ जी,
एनालिटिकल रीजनिंग का। वो ना
हम्म,
ये थोड़े से शब्द मुश्किल हो जाते हैं समझने, बिकॉज अंग्रेजी
हम्म,
दूसरी भाषा है हमारे लिए। ऐसे
हम्म,
आपने लास्ट बोला कि आप कंस्ट्रक्टिव क्रिटिसिज्म ले लेते हो,
हम्म,
ये भी थोड़ा सा एक कंस्ट्रक्टिव क्रिटिसिज्म होता क्या है, पता कर लेना फिर अगर बोलना है तो।
नहीं नहीं है, पता है सर।
अदरवाइज अच्छा, मतलब ऐसा पता कर लेना कि वो उस पर 2 सवाल पूछे तो आंसर पता हो, ऑब्वियसली पता
हाँ,
होगा ही। आई अंडरस्टैंड दिस, इट इज नॉट दैट लिटिल मीनिंग एंड द कॉमन पार्लेंस जिसमें यूज होता है वो मालूम नहीं होगा, वो मालूम होगा। जैसे
हम्म,
एनालिटिकल रीजनिंग में आप
हाँ वो मैं
एनिमल, तो अपने को ऐसा शब्द यूज करने से बचना है जहां से 4 सवाल निकल जाए। अगर
हम्म,
आपको एग्जाम, बिकॉज सीधा अगला सवाल मेरा भी यही होने वाला था कि व्हाट इज द लास्ट जजमेंट दैट यू हैव एनालाइज्ड।
हम्म,
वो फिर थोड़ा सा, जैसे सुखदेव कह रहा तो अपने हाई कोर्ट से गए गई है जजमेंट, तो यहाँ
हम्म,
पे आपने 4 सवाल बोले तो 5 सवाल पूछ लिए जाएंगे।
हम्म,
इतना ही है बस, ठीक है। सो दैट पार्ट, डोंट
ठीक,
डोंट use something which can be turned against you. Any
ओके,
sense. Although law and all that, as Karan ji has mentioned, is all well in line.
थैंक यू,
And I'm really hopeful कि हो जाएगा.
थैंक यू सर, थैंक
And
मैं
keep your
हनी, आपका
stress ready
इंटरव्यू
that
कब
day.
है?
यू सर। संडे,
आपका इंटरव्यू कब है?
संडे सर, संडे।
दिस संडे ना?
हाँ,
चलिए, बेस्ट ऑफ लक। 100% अब की बार लिस्ट में नाम आएगा तुम्हारा।
थैंक यू सर, थैंक यू सर। एक चीज पूछनी थी, ये सेकेंड इंटरव्यू बोलूँ क्या इंट्रोडक्शन में?
हाँ,
हाँ
मुझे
बिल्कुल
तो
बोलना चाहिए, ऑब्वियसली। उनको भी
ठीक,
थोड़ा सा दिखेगा कि मतलब मे बी पैनल में कुछ मेंबर्स वही होंगे जो लास्ट टाइम थे।
नहीं नहीं वो तो कोई नहीं है।
अच्छा चलो,
हाँ
बट
जी,
बोल देना है ना।
ठीक है सर।
ठीक है,
there are
ओके,
number
बेस्ट।
of people who have given four interviews. So don't worry.
ओके, थैंक यू सर।
ओके।